So the first thing I think we should understand is why is it that we're even looking at these sorts of things? What are the consequences if we don't follow the right process? I'm going to go into some detail of what those consequences are and also how you can manage those sorts of consequences. So the first thing is unfair and constructive dismissal. Unfair or constructive dismissal claims are worth up to 1 year's pay, capped at £83,682. But it is subject to an employee's ability to get another job. So what is an unfair dismissal claim? It is either that you do not have a fair reason to terminate an employee, or you have not followed the correct procedure. And the minimum requirement in terms of length of service to claim an unfair dismissal claim is at least 2 years. There are 2 exceptions in terms of potential liabilities where you don't need 2 years service. One is for discrimination, and which I'm going to deal with a little bit later on. And the second is for automatically unfair dismissal. So these are things like where you are dismissing somebody due to pregnancy or because of certain legal rights or being a member of a union, those sorts of things. The second thing I want you to think about is injury to feelings, or discrimination and harassment claims. So they are awarded under what is called injury to feelings, and there are 3 bands which actually increased this month. The first band for less serious cases is £900 to £8,800. The middle band is for £8,800 to £26,300, and the top band is £26,300 to £44,000. There can be certain cases where you would end up paying more than £44,000, but those are really extreme cases. The bottom band tends to be things like where there are one-off comments of discrimination. The top band would be perhaps when there is a discrimination at management level, almost like a conspiracy to get somebody out or discriminate against them in some way. And the middle band is kind of everything else. Even though there are those caps on discrimination, depending on the injury to feelings, there are certain claims where there isn't any cap. It's unlimited. So for example, if you're able to produce medical evidence to show that you can't work again as a result of the discrimination you have suffered, you could, in theory, receive your compensation or your salary up to the day that you would have retired. So it's really important to get it right, get the right things in place. I'm going to talk you through that today, okay? Okay, so the first thing that's important are employment contracts. Employment contracts are actually in handbooks, and I'll tell you why those things are important. What the law says is that you should be providing any new employees with a contract of employment within the first 8 weeks that they start their job. The consequences actually are very minimal. It's up to 4 weeks pay if it ends up in a tribunal, and you can't actually make a claim for not having an employment contract by itself. It's got to be on the back of an unfair dismissal claim. So in reality, more from a practical point of view, the purpose of an employment contract is just to have certainty of terms. As an employer, this is what I'm offering you, this is what I'm paying you, this is what your entitlements will be while you work for me. In exchange, I want you to do this for me. So everybody's clear what the terms are, what the expectations are. It will include the start date, hours, pay, notice, holiday entitlement, all those sorts of things. And the idea is to avoid a dispute. If you've got it in a document, and as long as the reality of the situation reflects what it is that's in the contract, well then that avoids any disputes arising later on, because you can refer to the contract. Another important thing you should have in an employment contract are what's called post-termination restrictions. That means stuff that employees can't do after they leave the workplace. So that normally means things like stealing company clients or their suppliers, or doing anything that could damage the business in some way. And the point of that, there's normally a period of restriction. Usually it's somewhere between 3 to 6 months, depending on what's reasonable, that they can't do those sorts of things. So it allows an employer to reconnect with that client. Most people by people. So it's understandable that when an employee wants to leave a workplace, they may sometimes have a connection with the client, but the client will want to go with them. So the restriction prevents them from doing that, or they could be sued for any losses that an employer has as a result of that, if they do that. And it allows the company a period of time to reconnect with the client. The second thing is if you don't have expressed terms, if you don't have it in writing, you're relying on implied terms. You're relying on a course of conduct to decide what the employment relationship is. So the more clarity you have, the clearer you can be on what is expected of each other, the better. Again, it just avoids disputes. Also, repudiatory breaches. So if it's set up very clearly in the handbook and in the employment contract what it is that's expected, despite how obvious it may seem, you are less likely to have problems in the workplace, or if there are problems, you can rely on the documentation to show that the employee was made aware of what was expected. Even things like if you want to change terms and conditions, it's good to have a variation clause in the contract that allows you to do it. In any event, any changes in terms and conditions would have to be reasonable in the circumstances and depend on what the circumstances are. But having the contract, any variations in the contract. And also, you can, with the handbook and the contract drafted in the right way, you can actually justify a termination, because again, it's spelled out to the employee what is expected of them. Company handbooks. So the purpose of a handbook is really, it's a guide. It's supposed to show the employees, this is how we operate, this is how we do things. So don't make it contractual, make it a guide. If it's contractual, you're obligated to follow the processes that are in there, but if it's a guide, it can be more of a suggestion of what we're doing. It will have things like your paternity policies, your maternity. It will have things about how the internet is supposed to be dealt with, or email policy. It will have things to do with your disciplinary and grievance procedures. You should have all the things on how we operate, so it's a manual for staff so they know exactly what's expected of them. In addition, if you've got a company handbook and it's got things in there like equal opportunities policy that explains how you shouldn't be discriminating, how you shouldn't be bullying staff in certain ways, if they do those sorts of things and the employer ends up in tribunal because of an employee's actions, you can rely on what's called a statute of defense. There's something called vicarious liability, which basically means as an employer, you're responsible for the actions of your employees. It's a bit like a parent-child sort of a relationship. So if you've got a handbook and they've been trained on how they should operate in the workplace, actually even sometimes perhaps on work do, so it's out of the workplace, but it's in a work context, and they still act in a way that is unacceptable, like sexually harassing somebody or hitting on somebody or being offensive to somebody in some sort of discriminatory manner, well, the company can say, well, look, we can say to a tribunal if it gets there, look, we did everything we could do to stop that from happening. And so that's called the statute of defense. Again, it's important you get those things in place just to protect the business. The other thing is to consider the reality of working practices. It's not just about protection from employment tribunals. It's also about perhaps creating a certain culture, a certain work practice, a certain way that you want staff to behave and operate, so you know that this is how we do things. Let me just have a quick check and see if there's any questions. There's a chat there. No, that's fine. So redundancies. We get queries about redundancies on quite a regular basis, in fact. Sometimes I've got clients that want to think it's a redundancy situation, but then they start talking about the performance of the employee or things not working out and those sorts of things. So I want to go through a fairly simple way to deal with redundancies, or look at it in a simple way, regardless of the complexity of it, okay? But the majority of what I'm going to be dealing with right now deals with employees where there are less than 20 employees in a redundancy pool, but I'll touch on a few other bits and pieces. Then let me go into the next slide. So, what is a redundancy? Redundancy is where there's no longer a requirement for a job of a particular kind. It doesn't mean job titles, it means the work that you're actually doing. There's three types of situations where a redundancy will take place. The first one is where there's a business closure, where obviously everybody will lose their job. The second one is where there's not enough work. So we haven't got enough work to sustain the same level of staff. So I've got 10 employment lawyers and we've only got enough work for 5. Obviously, 5 of them are going to go. We've got to decide how it is that those 5 will go. I'll explain that process a bit later on. And the third redundancy scenario is a restructure. Perhaps there are increased efficiencies or improvements in technology, which means that you don't need the same number of staff to carry the work that's been done. You can use less staff to carry out the same work. So those are the three types of category: business closure, everybody loses their job, not enough work, or where there's a restructure and they don't need as many staff. So once you've established a genuine redundancy in law, you need to have a fair procedure. The procedure is these stages. The first one is to have meaningful consultation. There's no rocket science to it. It just means speak to the employees and exactly about what is happening, why they're at risk of redundancy, what the process would involve, what they'll be entitled to if they're made redundant, all those things. Let them know exactly what the situation is. The period of consultation for less than 20 employees isn't prescribed. It's just got to be a reasonable period of time. That could be a couple of weeks, quite frankly, but the longer the period of consultation, the more reasonable it's going to be. The second, the period of consultation will obviously be prescribed. If it's between 20 to 99 employees, then you have to do at least 30 days. consultation before the first of the dismissal for redundancy. If it's 100 or more redundancies, you need to have at least a 45-day consultation period before the first of the dismissals take place. If there are employee reps or union representatives who need to be appointed as part of the consultation process, there are a few additional procedures that are required. I won't go into that now to appoint those people. The next phase, so meaningful consultation is number one. The second thing is a fair selection. So obviously, if it's just one person doing a job on their own and nobody else is doing the job and there's no longer a requirement, there's no requirement for a selection process. That person is selected, obviously. But if there's a number of different people that are in a pool, so there's a downturn in work, let's say, and it affects, let's say, a downturn in sales, and so the 10 sales staff are now affected. So what you realize is because of the value of the sales that are coming in, you only need 5 out of the 10, let's say. So you need to apply a criteria that is objective, fair, and reasonable. What that means is things that are relevant to the job. So maybe it's the ones with the highest targets, for example. Maybe it's the ones that can create the most appointments. Maybe it's the one that can do just the most business, as simple as that. Maybe it's the ones that travel around, or whatever the criteria are for those sales representatives in this example, you've got to apply it. And if the more measurable it is, the more objective and reasonable it will be as well. You can't be doing anything on the basis of it being a personal relationship or cherry picking staff. That's going to be unfair in law. And then you're going to be looking at claims for unfair dismissal. The next step is looking at suitable alternative employment. Just because the job is redundant doesn't mean that the employee is redundant. So you look at suitable alternative employment. I mean, something keeping with their skills, jobs, qualifications, whatever it is that will enable to see whether they're suitable for that role. If you're not sure, you can have a 4-week trial period for either the employee or the employer to decide whether that is a suitable alternative role or not. If it's not, then the redundancy kicks back in. There's not a legal obligation to consider this, but it might be fair in the circumstances, something called bumping. So I'll give you an example. Let's say, for example, I work in an employment law firm that does other areas of law as well. We don't, but let's say we did. And I was selected for redundancy because there's not a requirement for as many employment lawyers anymore. And I could say to my employer, well, actually, I'm really good at conveyancing law, and I could do much better than the conveyancing lawyer. Well, in those circumstances, what could happen is you could put the conveyancing lawyer, even though there was no risk of redundancy for that conveyancing lawyer, you could put them in a pool with me, apply a criteria again to determine who the best people for the job, the best person for the job is, and whoever scores most highly according to that objective and measurable criteria will stay, and the one with the lowest score will go. So consider bumping if there is some other role that they might be able to do. Somebody else is made redundant. The key, if you forget everything else, is you just want to be able to demonstrate that redundancy was the last reasonable resort. If you're able to demonstrate that, you won't go wrong. Terminations. Now we've got Peter. Peter's got a quick question here. The number quoted for redundancy consultation, are they the number of people being made, but not for the total of employees at that point? So it's the number of employees in the pool, not the ones that are actually being made redundant. It's the number in the pool that you need to look at, Peter. Hope that answers your question. Okay, terminations. I think this is an important one. There's 2 things you need to think about. One is for a lawful, again, these are for employees with more than 2 years service. With less than 2 years, you can dismiss an employee with notice pay and their holiday entitlement and any other contractual entitlements, as long as there is no discrimination involved and nothing that is automatically unfair, as I mentioned earlier. But otherwise, it's open season effectively. But for these terminations I'm talking about are for 2 years service or not. 2 years is the magic number because you need 2 years service to be entitled to even claim unfair dismissal. There's no jurisdiction otherwise. So the disciplinary process, I'm going to also address grievance procedures because I'm going to be talking about discrimination a bit later on, and I think that might be useful for you as well. So you need a fair reason and you need a fair process. So the length of service, the first thing to think about is 2 years. If they haven't got 2 years and there's no discriminatory factors and there's no other automatically unfair considerations with that person, you can dismiss them with notice. You don't have to follow any process at all. If it's 2 years or more, you need to follow a 3-step process. And you need 2 things. The first thing is a fair reason and a fair procedure. Fair reasons include misconduct, redundancy, illegality. It will be some other substantial reason. It will be a number of different reasons that you can justify as long as it falls within a specified category. The second thing you need to follow is a fair procedure. The fair procedure is a 3-step process. It's a reasonable investigation, having a fair and reasonable disciplinary, and then offering the right of appeal, which is also conducted fairly and reasonably. The way I've often described this to clients a bit tongue-in-cheek as a bit like super nanny law. If you've seen Super Nanny, it's that program where there's that nanny going into houses looking to help parents dealing with unruly children. And so what they go in there is they tell the children what they expect of them, and if they don't do certain things, there's consequences. And if they don't do those things, the consequences are they end up in the naughty step. And that's effectively employment law. They end up in the naughty step, or they end up in the disciplinary process. The disciplinary process is you first give a verbal warning, first written warning, final written warning, and then they're out. And you can jump certain disciplinary processes if the level of the offence warrants it. So the key thing here is having a fair process and a fair reason. They also have, the process includes, you have to write to them, testing out exactly what the allegations are, and providing them with the supporting evidence. At the disciplinary itself, they've got to have the opportunity to state their case and challenge the evidence, and they'll also have the right to be accompanied. Right to be accompanied means by a trade union representative or a fellow employee from that company. It doesn't mean their mother, their brother, or their mate. In certain extreme circumstances, it could mean a lawyer, but I'm going to ask you to ignore that I've said that for the purposes of this webinar for various reasons. So it's got to be a trade union representative. They've got to provide the necessary credentials to be able to accompany them. It doesn't matter whether you recognise the trade union or not, as long as they are trade union official. And also, they've got they can make representations, but they can't answer questions on behalf of the employee. The next thing I want you to think about is the burden of proof. This is a really important bit when dealing with disciplinary or grievance procedures. So the way to look at these things as evidence, the way that employment tribunals or judges look at these things, is on what's called a balance of probabilities. You're probably familiar with criminal courts where the burden of proof is beyond a reasonable doubt. Employment law is a much lower burden. It's on a balance of probabilities, which in English means, what does it look like? What does it look like? It doesn't even mean what is the truth. It means what does it look like? It's a 51% rule. So if there's 10 people that say something happened in the daytime and one person says it happened in the nighttime, as a silly example, the chances are it's going to be in the daytime, the majority. The only way you can shift that burden if all those 10 people are lying is if the one person can show that they're lying. If there's evidence, other evidence that indicates that, or that doesn't add up, again, that makes it look like they're not telling the truth. So it's a balance of probabilities looking at all of the evidence that's provided to make a decision. We have lots of clients where sometimes there's one person's word against another. It doesn't mean you can't make a decision. It just means you've got to explain why you attached more weight to one person's version of events over another. And if that's fair and reasonable, that will be valid. Again, I've said about having the fundamental right of appeal. When you do an appeal process, you should do it as a rehearing, not merely a review. A rehearing means looking at everything in the round, the whole situation. A review appeal hearing means that the employee, let's say, is dismissed, and they only appeal on certain points of the dismissal, A, B, and C. But actually, we looked at A, B, C, D, E, F, G in the whole situation. So a rehearing will remedy any defects that might have happened in the disciplinary process leading up to that. Got a couple of questions. Let's have a quick look. Okay. So Joe has asked, what if they're pregnant? I have a member of staff who has poor attendance before her pregnancy and is now being signed off weekly. Well, those are slightly more complicated in the sense that you need to be very clear, Joe, on what it is that is behind the reason for the dismissal or any action you're going to take. As long as it isn't related to the pregnancy and you can clearly demonstrate that, and I say clearly demonstrate that because you don't want there to even be an inference that it's related to the pregnancy, then you'll be all right. You need to have sufficient evidence to show that it's not related to the pregnancy, any reason that you're going to be terminating your employment. Happy to talk to you privately in more detail if you want to give me a call about that. Veronica's asked a question here. I presume you have to give a reason for dismissal if it's under 2 years. Does it have to be in writing? So the only reason you have to give or should give a reason if it's less than 2 years is just to avoid them being able to say it's something that you don't need 2 years for, like because of discrimination or anything that's automatically unfair. So if you're going to dismiss somebody from a certain ethnic minority, let's say, then you present some reasons to show what it is, and you can back that up. If they do bring up a race card, for example, then you would be able to say, well, no, we've got all the evidence to back up why it is that we said that these were the real reasons, and here's the letter that confirms it. So that's the only reason you would, if there was a smell of discrimination or anything that's automatically unfair, then I would say definitely put that in writing. Eric, it says you are right, and it needs to be confirmed in writing, but do you give a right of appeal? So this is only for over 2 years service. Yes, you do. You have to give it's a fundamental right of appeal, unless you've given it as a contractual right, like in a handbook, then you would be contractually obligated to do that. Joe, yeah, give me a call. So let me go through the next one. My number's at the end, Joe, at the end of this webinar. I've got my details. Okay, so grievance procedures are mirroring disciplinary procedures. So a grievance is anything that an employee wants to complain about, quite frankly. Literally anything. And the process should be, I'm not saying jump straight into disciplinaries, I'm not saying jump straight into formal grievances. I would always say have an adult conversation with the employee, whichever scenario it is, disciplinary or grievance, if possible. With the grievance process, they put it in writing. You investigate that grievance. You have a grievance meeting. They have the right to be accompanied at that grievance meeting, and they have the right to appeal against that decision. It's exactly the same. The outcomes tend to be either a conciliation. So maybe there's two employees that have a workplace dispute, perhaps a settlement, which I'm going to talk about in a minute, or it could end up in tribunal. Other outcome could be you just don't find in their favor and there's sufficient evidence that perhaps was brought maliciously, in which case you could consider taking disciplinary action against that individual, but you need to have pretty strong evidence. Okay, without prejudice discussion. So I've talked to you about the formal process of going through a disciplinary process before you dismiss somebody. Compromise is the cheapest lawyer. It also saves you time. Sometimes, people get lost in the rights and wrongs of the situation. I'm not saying that's not valid, but from a commercial point of view, if it costs them £5,000, let's say, to get rid of an employee under a settlement agreement, which if you don't know, it's for want of a better phrase, it's a payoff. It's a legally binding document. You will pay them, and in exchange for that, they will not sue you for anything arising in sue you for a claim in an employment tribunal. So what you should think about is, well, the time it's going to take to go through a tribunal. It's a cost to you as an employer, as a company, and your managers to take time out to have to deal with a tribunal case when you could probably be making that money back much quicker. There's going to be legal fees that are incurred as well if you're going to instruct a lawyer, obviously. If you have insurance, that might not be an issue for you, but obviously if you do claim on an insurance policy you have, that's likely to increase the premium. Without prejudice discussions are off the record, inadmissible discussions that you can have with an employee to say why it's not working out. And the way to, or the amount to think about, if you're thinking about unfair dismissal, discrimination is slightly more complicated, so I won't deal with that in this webinar. The way to think about it is, what's it going to cost me if they win at a tribunal, and am I prepared to manage that? And the way to think about it is, it's worth up to 1 year's loss of income, subject to their ability to get another job. That means if they can get a job within 3 months, you're looking at 3 months paid as a potential value of a claim. And you might think it might be worth paying them 3 months rather than going through a verbal warning, first written warning, final written warning, which could take 6 months to get them out, and you're paying them six months pay. So those headache employees, you would think about getting some proper advice, obviously. I know I would say that, but it's correct. Get the right advice, get it from us, and we'll tell you exactly how it is that you can deal with those sorts of situations, and how it is that you can then just get on with running your business in the way you want to. But I would always advocate having early, grown-up conversation with staff. If it's not going to work out, see if we can explore an amicable separation. Okay, let's have a look at another query. Let's have a look at that. Okay, question from Sasha. I was advised that the employment contract should set out to whom an appeal should be made. Would this then render the appeal a contractual right? Well, I mean, the difficulty, I suppose what it would say, Sasha, is probably who it is as in the job title rather than a specific individual. And I suppose if you've got it in a policy, again, it depends whether you say at the beginning of the handbook or that policy, whether this is a contractual document or just a guide. If it's a contractual document, then you're right, then it renders it a contractual right. If you said at the beginning it's not that, then it won't. Okay. Okay, how are we doing for time? I'm conscious that you're in your lunch breaks, so let me speed on. So, unlawful discrimination, harassment. A lot of people think discrimination is just treating somebody less favorably. I often get the situation, I'm being harassed, I'm being discriminated against. But there's a specific legal description. If I discriminate against you because you're a smoker, for example, it's not unlawful. I am discriminating against you. Obviously, I'm treating you less favorably because you're a smoker, let's say. But it's not an unlawful discrimination. There's specific characteristics, specific laws that you need to be discriminating as a reason behind this, a purpose behind why you're discriminating against them for it to be unlawful. Harassment is also that. Let me go through that with you right now. So since 2010, there's 9 different types of discrimination laws that you should be aware of. Age, disability, gender reassignment, marriage or civil partnership. Strangely, there's no protection to discriminate against somebody who's single, but there you are. Pregnancy, maternity rights, race discrimination, religion or belief, sex or sexual orientation. Those are the 9 areas or categories that you can't treat people less favorably based on those things. There's 4 types of discrimination that I want you to discuss here. There's also a 5th one I'm going to refer to after this slide. Direct and indirect. Direct discrimination is I'm treating you less favorably, for example, because you're a woman. That is clearly direct discrimination. You're a woman, I'm treating you less favorably. Indirect discrimination would be where I put in a provision or a criteria or a practice that would affect a majority of one of those categories. So I think there used to be a thing where they would have a specific height for a police officer. And what they found was that the majority of people that it indirectly discriminated against were women because they were a certain height. So they had to remove that unless you can show it as a genuine occupational requirement. By association or perception. So this means you don't even have to have that characteristic. So if somebody is being abusive to somebody else because they believe, let's say they're calling them gay, for example. I get that quite a lot in workplace issues. And they're not. Well, that person can still make a claim for discrimination based on the perceived sexual orientation. You don't have to have the actual characteristic, even by association. You don't have to be of a, for example, if somebody is discriminating against somebody because of their ethnic minority, or a certain race, a certain religion, or anything of that sort of nature. If you're connected with them in some way. So, for example, if you were married to somebody of a certain ethnic minority, but you weren't of the same ethnic minority, and you heard comments of that sort of discriminatory or racist nature, you could also make a claim for that as well. Harassment I'm going to deal with in the next slide. Third-party harassment is where, for example, if I send one of my staff out to a client site and one of the clients decides to sexually harass them, I've got an obligation to protect my staff from those types of situations. Okay, harassment. So I want this is an important thing, I think, to get your head around. A lot of employers, I think, find this tricky to get around. So harassment is defined as unwanted conduct related to a relevant protected characteristic. So let's just use the example of being a woman, for example. So unwanted conduct towards a woman which has the purpose or effect. That's an important one because most people say I was only joking or I didn't mean it. Or perhaps it was part of some sort of office banter and, oh, we were just a joke and it was going back and forth. But you know when that changes is when one person decides it's not banter anymore. The purpose or effect means either I'm treating you less favorably on purpose because you're a woman, in the example I'm giving you, or race or disability, what have you, or I don't mean it, but that's the effect it has. And the effect it has on you as a result of this unwanted conduct is it either violates your dignity, it creates an intimidating, hostile, degrading, humiliating, or the very lowest bar is offensive. You just have to be offended. That applies even if it isn't directed at you. So there was a case where there was an employee, a female employee, who saw a group of men in an adjacent office where there was a glass partition. She was aware that they were looking at pornography in that other office. She didn't see any of it. She wasn't witness to it. There was no discussions about it, but she was aware of it. It was enough that she found that environment degrading, hostile, offensive, and she won a claim for sexual harassment. So the 2 things I want you to be clear about is it doesn't need to be directed at an individual, and they don't even have to have the characteristic to be protected by harassment law. Perception or association still counts. Victimization. So victimization law is there to protect employees who raise a grievance. So if you raise a grievance and then you can be treated badly afterwards, well, obviously people will be scared for any sort of action taken against them for bringing any complaints. So victimization says is if you raise a complaint for discrimination because of a disability, let's say, and you're treated badly because you brought that complaint, and it's because and you raised a grievance and it falls within the Equality Act. Well, then you would be entitled to, that person would be entitled to claim, again, up within the 3 bands for injury to feelings, up to £44,000. So it's really important that you don't treat people less favorably as a result of bringing these complaints, even if they're ill-founded. So if a person brings a complaint believing it to be true, it's brought in good faith, but it turns out that it's ill-founded, you still cannot treat them as favorably as a result, as long as it was done with integrity, so to speak. If it wasn't, if it was done maliciously, then that protection doesn't apply. There's no comparator that's required for harassment law as well. Discrimination law normally requires discrimination means a difference, less favorable treatment than a man has been treated, if it was a woman claiming sex discrimination, for example. But harassment doesn't require that comparison. It takes into account, for example, in the old law, if you treated a man and a woman equally as badly, well, it wouldn't be discrimination because you're treating them both badly, whereas harassment takes into account how individuals will feel in certain circumstances. Okay, we're coming to the end of the slide now. So, what can you do to protect yourself? Train your staff. Get induction processes in place right at the beginning. If you haven't got them already, it's not too late. Get them trained up. Get them trained up on the handbook. Tell them what's involved. Give them equality training. Let them know how you expect them to behave. Tell them what the consequences will be. There's consequences to them personally. For discrimination law and harassment, there's a vicarious liability to the employer, which I mentioned earlier, like a parent-child relationship. But for discrimination and harassment, an individual can also be personally sued. So if you get these things in place, you've got a statutory defense because you've taken all reasonably practicable steps to stop employees treating or behaving in a certain way to other employees. Then you as a business will be protected, and the employees are kind of seen as being on a kind of a frolic of their own, so to speak. You want to be able to tell that to the employees and the agents of the employees as well, to anybody representing the company, so that the company is protected. That's pretty much it for this seminar. I appreciate the webinar. I appreciate it's quite a lot of information I've kind of shoehorned in. I hope you kind of got some tips of what you're looking for. If you need anything more, my door is open or my phone is open. Please call me, email me. There's no obligation whatsoever. I'm happy to talk to people and see how we can help in any way whatsoever. If there was anything that was unclear in this webinar, let me know that as well. If you'd like a copy of the slides, in fact, my team will probably send a copy of the slides if you request it anyway. We will be asking you for some feedback, but more importantly, we want to be doing this every month, and we want to be able to provide some information that's useful for you on a day-to-day basis. So let us know what topics are of interest, what problems you've got that would be useful in terms of your business and helping you move forward. My details are there. There will be a recording of this webinar that will be sent to you at the in due course. But you have my details. Google Astute HR. You will find us if there's any other questions you have. I hope this was useful for you, and thank you very much for registering with this. And I'll see you again next month. Bye-bye.